How do I know that my employment-related settlement agreement will be a legally binding document after I've signed it? I'm Richard Hiron, also known as the Hironator, and I'm an employment law solicitor. There are various Acts of Parliament and regulations that govern the drafting and enforceability of a settlement agreement. Essentially, they provide 6 conditions for a settlement agreement to be legally binding both when it's offered and in the future, and I'm going to guide you through those now. The first condition is that the legally binding settlement agreement must be written. It can't be something where somebody essentially says, I'll give you this amount of money if you agree to leave. It all has to be set out in a written document. Point number 2 is that the settlement agreement has to relate to particular proceedings or a particular complaint. So this could be a grievance, it could be a disciplinary, it could be an employment tribunal claim, or it could be a court claim, or it could be something else entirely, as long as it fits within that definition of a complaint or proceedings. Point number 3 is that you have to receive legal advice from a relevant, independent legal advisor. I'll go into that in a bit more detail in another video because it's a bit too much information for now, but it's actually quite important to bear that in mind. Point number 4 is that that relevant independent legal advisor has to have advised you on the terms and effect of the settlement agreement and how it might impact your rights to bring claims in the employment tribunal or the courts. Point number 5. Now this point is that the relevant independent legal advisor has to be identified in the settlement agreement by name. So you have the name of the advisor. You might then move on to the name of the firm or the organisation that they represent, and then the address of that firm or organisation. The sixth and final point is that the settlement agreement itself has to make reference to those regulations and Acts of Parliament that I've mentioned. So the safest way to do this, rather than just saying it satisfies all of those conditions, is to physically set out the Acts of Parliament and the regulations in the settlement agreement so that there can be no mistake that they have been covered. So those are the 6 points that make a settlement agreement legally binding. They have to be figured in some way into the settlement agreement for it to be legally binding. So, after all of that, I hope I've answered the question. In the meantime, if you're finding a settlement agreement hard, bring it to Richard.